My name is Sid Mendelson. On my right is Howie Hollick. On his right is Mark Goldfuss. On his immediate right is Glenn Payne. And at the end of the table is Arthur Brown. Go ahead.
I'd like to finish up some material that's on a previous tape covering Section 17D. First of all, there are two methods by which a transaction which would otherwise be covered by 17D could be exempted. The first method is by the filing of an application with the Commission. In paragraph B of Rule 17D1 sets forth certain criteria which, if satisfied, will permit the issuance of an exemptive order. The second method can be found further on in Rule 17D1, and in the rule there are a number of different arrangements which are specifically described, which may be carried out without the filing of an application. Perhaps the most important of these rules is found in paragraph D5 of Rule 17D1. And generally, this rule permits a transaction to be carried out without the filing of an application, so long as certain enumerated persons upstream of the investment company do not participate in the transaction. These persons would include officers, directors, investment advisors, employees, controlling persons, and 5% shareholders of the investment company. Now, in addition to that, the rule specifically provides that the investment company or the controlled company, if the controlled company is participating in the transaction, may not commit more than 5% of their total assets to the transaction. This 5% limitation would not apply in the situation where a small business investment company is the investment company participant. In that case, up to 20% of the paid-in capital and surplus of the SBIC may be committed to the transaction. One other item worth knowing about in this rule is that if you have a situation where a controlled company of an investment company is merging with another controlled company or with another portfolio affiliate of the investment company, then more than 5% of the assets can be committed. In other words, the entire assets of the controlled company can be used in the joint transaction. I think that covers the rule pretty well, unless there are some questions.
I have a comment to show what the rule was really trying to get at. We had a very anomalous situation where say an SBIC and another company totally unrelated to the SBIC would get together and determine that each of them were going to put a certain amount of money into a small business. And let us say that the SBIC would put in enough, say 10% of the voting would buy 10% of the voting securities of the small business company, and the other company would buy say 10%. And a strange thing happened by that. Here are two people who, at arm's length, decided to put 10% to buy 10% of the voting securities into a common company, a portfolio company. Suddenly, even though they were at arm's length, the other company became an affiliated person of an affiliated person of the investment company. In other words, the other company would own 10% of the portfolio company that would make those two companies affiliated persons of each other. The portfolio company, by virtue of the fact that the investment company owned 10% of its voting securities, was an affiliate of the portfolio company. So this transaction at arm's length would create the anomalous situation of this other company, this co-investor, being an affiliate of an affiliate, if for another transaction totally unrelated to this transaction, they decided to go into another joint venture with each other, they'd have to come to the commission and get an application because get an order, because here was an affiliate of an affiliate doing business with the investment company, and they had no relationship at all, no chance to overreach because of a position, but simply because of a previous transaction that they had gone into. And this was the subject of a great deal of criticism of the act and of the way the staff interpreted and the commission interpreted the Section 17D. So if there is one thing that 17D was promulgated to correct, it was the situation that I just set forth.
Incidentally, there is another provision in Rule 17D1 which is specifically designed to cover the situation where you have a small business investment company in a joint transaction with a portfolio affiliate in which another person also has an affiliated relationship. That provision is basically designed for the situation where a bank, for example, has more than a 5% ownership in a common portfolio affiliate with the investment company, and there banks were concerned, for example, that if they made additional loans to the venture capital operation, or to the small business company, that they might be picked up by the rule, and the purpose of that other provision that I'm speaking about was meant to exclude that situation from the reach of 17D.
17D1, D4?
I believe it was 3.
But 17, the rule that is really a companion of 17A6, and the same general principles that would govern the interpretation of 17A6 govern the interpretation of 17D1, D5. Okay.
Sid, if I can just get back to the application exemptive standards for a second, because I think they're very important in view of the fact that we do get a very high percentage of our applications filed either under 17B of the Act or Rule 17D1. It's interesting to note when you look at the standards in 17B and the rule that they are different. I think you're looking almost at the same factors in reviewing a 17A transaction, that's a sale or purchase, and a 17D joint transaction. But the problem we talked about yesterday involving looking out for industrial companies, non-investment companies, which comes up in the 17A context because we talk about overreaching on the part of any person concerned, does not come up as clearly in the 17D situation, because Rule 17D1B has a standard that we look to the public interest and the protection of investors, and also to see whether the participation of the investment companies involved is less advantageous than the other participants. So in the case where the advisor or an affiliate and the investment company are on one side of the table dealing with some third party, if they seem to be getting a good deal, at least from the information you have, that is not really of great concern. At least that would, if you consider the good to be the deal to be advantageous, the standard appears to be met, barring any other facts. If that was a 17B transaction, the issue arises as it has, except for the rule that takes out the downstream affiliates now. The issue arises as to whether if we're in the business of protecting the non-investment company.
Okay. Fine. Any any questions? Then let's go on.
Okay. We're now going to move to Section 17E of the Act and move to the concept of agency transactions as opposed to principal transactions. 17E is not legally a difficult area to deal with, but the challenge of Section 17E, particularly to examiners in the field, is applying particular fact patterns to the prohibitions of the Act. Section 17E is intended to prevent conflicts of interest, period. If a conflict of interest exists in any transaction that you see other than a principal transaction, look to Section 17E to see if its prohibitions apply. Section 17E of the Act consists of two paragraphs. The first paragraph is the prohibition. Basically, it says that an affiliate acting as an agent can accept any compensation, except his salary, from any source in a transaction that he's doing on behalf of the fund, and that doesn't mean a securities transaction only, it means anything he's affecting on behalf of the fund, except in his course of his business as an underwriter or a broker. The second paragraph of Section 17E regulates when he may accept compensation in the course of his business as a broker. The question of when he can accept it as an underwriter will be discussed in a few minutes when we discuss Section 10F of the Act. Now, really, all this section involves is a linking of some key phrases. First, acting as agent. He must be acting as agent on behalf of the investment company. It does not require a quid pro quo. It doesn't require that he's acting in consideration for the compensation that he's receiving from some party. It's only that he's accepting compensation and he's acting as agent. Now the case that discussed that was U.S. v. Deutsch. That's D-E-U-T-S-C-H, which was a 1971 Second Circuit opinion. U.S. v. Deutsch, extremely important in Section 17E. Now the second key phrase is any compensation. Now the general test that people are applying now comes from the jury charge in the trial in U.S. v. Deutsch. Was a criminal trial, and that is, it's a benefit or thing of value. Now, in that case, the benefit or thing of value he was receiving was the ability to purchase certain securities at a discount price. We've had other cases like that, one dealing with the IDS complex, where a trader was getting the institutional price from market makers and not the price that an individual would get. But the thing I want to emphasize here is when we're looking at benefit or thing of value, it doesn't necessarily mean a quantifiable in dollars and cents benefit. We're looking for conflicts of interest. We're not the IRS looking for something to tax. It could be, for example, the guy promising that he'll get him into a country club, that'll get him the presidency of the Lions Club, that'll get his son bar mitzvah lessons, anything that the person who they're trying to influence would think would be of value to him. It doesn't have to be property. It doesn't have to be real property. But it just has to be something that this person's judgment would be influenced so that he's not dealing with an eye single to the investment company. The third key phrase of the three key phrases that Section 17E consist of is the compensation can be from any source. Now, to give illustrations of that, let me just cite a couple of cases. In a very recent district court decision, Pupco v. Dickinson, which is really the other name for SEC v. Dickinson, which involves the Sun Company attempted takeover of Becton Dickinson, the investment advisor had an opinion from highly respected counsel saying that if he tendered the shares, let me step back one bit if I could. The investment advisor was a tender offer solicitor for the Sun Oil Company. He would only get compensation if enough shares were tendered. In other words, he was acting on a contingent fee basis. Now, the agreement that he had is that the tender offer solicitation fees that were attributable to the shares tendered by the investment company were returned to the investment company. In other words, we don't have the type of thing that happened in Stedman Corporation where he kept it for his own benefit. The advisor, who was also acting as a tender offer solicitor, kept the fees there. Here the fees were returned, but yet the court found a Section 17E violation because those shares were quite likely needed for him to reach the threshold level where he would get his contingent solicitation fees. Therefore, although he wasn't getting money particularly for the shares tendered by the investment company, those shares were so important to him that no one could say that he was necessarily acting with an eye single to the benefits of the investment company. Again, the commission, the court in this decision really brushed aside an opinion letter from a highly, highly respected securities attorney. Let me give you another example, if I could, and this involves a commission decision in Investors Research Company. There, the fund's advisor sold computer software services to a broker-dealer, and that broker-dealer received a highly significant share of the fund's brokerage. Now, the commission in there nowhere found that anybody acted with ill will, but they said Section 17E was violated nonetheless. You can see why. Money was flowing from the fund to the broker-dealer and from the broker-dealer to the investment advisor. Anytime you see anything like that, it's got to ring a bell. It's got to be a dangerous situation.
Now, these things are not obvious. Many times, as I'll get into very briefly after Mark is through, the 17E doesn't come up and hit you. Some of these payoffs, if you will, or compensation, are quite subtle, quite subtle.
Yeah, while we're on both of those cases, I think there's another point to make that arises out of both fact situations. In the Sun Oil case, the tender offer price for the shares which Chemical Fund and the other Eberstadt funds received or would have received was very good. It was well over the market. And because of the way the tender offer in that case was arranged, it would not have been available to them in the market. This was not going to be a tender offer to all public shareholders. So on the face of it, the investment company got an advantage. They got, I don't know the numbers, but a 50% premium over market value, I think, was in the right neighborhood. Likewise, in the Investors Research case, it's not as clear, but it may be that the brokerage or the research that the broker who supplied 20th Century with their brokerage was good. The execution might have been not in and of itself something that an inspector or anyone else would go in against the fund on.
Well, that was a little cruder. That was somewhat cruder.
There was certainly some cases where the execution was bad, but as a whole, I don't think there was any finding that the execution was bad.
Not in the execution. The fact was that wherever the registered rep went, the hardware went. The registered rep always, if he went to broker-dealer A, the broker-dealer A bought the hardware or rented the hardware from the investment advisor, and just coincidentally, the that broker-dealer received the lion's share of the funds brokerage, yeah. And he went someplace else. That broker-dealer rented the hardware, and the brokerage followed.
Right.
So that's what I meant by crude.
Sure.
We had nothing, although there was some problem with execution. It didn't pose a big factor in the case. The factor was that the staff was interested in that the hardware and the brokerage always went hand in hand for a quid pro quo.
Right. just to elaborate on that for a second, the hardware was tied up with the research and the procedure whereby stocks were selected for that fund, and that fund was ranked number 1 out of 400 in its performance for a few years. The only point I'm trying to make, and I think it may be a very useful one, in both of these cases, the fund, it looks like the fund got a better price for its security, its performance was good as a result of the arrangement that's still subject to 17E. So as Mark says, it prohibits conflicts of interest. You don't have to make a judgment as to whether the conflict hurt the fund or aided the fund. And in some respects, that may just be coincidental. But the idea is once you have the affiliate and the fund acting in the concert that's required by 17E, the fund doesn't have to lose money or be disadvantaged in the price it gets or in the way it is handled through the transaction.
Well, which brings up the same situation or the same statement that I mentioned earlier. 17 is prophylactic. You're dealing with fiduciaries here, and the act, if you will, goes out of its way to prevent transactions that have the touch of a conflict of interest. In the Becton Dickinson case, one will never know whether it was the fund's whether the investment advisor in tendering the shares of the fund to Sun really did it for the fund's benefit or for his own benefit. And that's the key, if you will. The conflict of interest that put him in that, the compensation that he was going to get. I might say that one should not lose sight in the Becton Dickinson case to the fact that there was a very large block here that the funds had. And this block meant the difference of whether it could have meant the difference as to whether this tender offer was successful or not successful.
That's right.
So delivering those securities was essential to the takeover scheme of Becton Dickinson.
That's right.
And concomitantly, it was essential if the investment advisor was going to get this gigantic fee, those shares appeared to be essential to be tendered. So he had such a conflict of interest that one will never know, as I say, what motivated him to deliver those shares.
That's right.
And with respect to the giving back of the fees, while this was put in as a defense, one does not know whether the return of the fees was an afterthought after the opposition machinery started to go into place, plus the commission's investigation, or
they had a letter beforehand,
or whether this was a method in which they felt that they could obfuscate what appeared later to be a 17E. Commission was rather worried about that, brought the division up to discuss this matter, and the division, taking all the facts into consideration, supported the enforcement division in the inclusion of 17E as well as 17D in this complaint.
Mm-hmm.
I would like to say something just to give you the flavor of Mark's 17E. Just what happened in the case with respect to the IDS situation, which Mark is alluded to, where a trader on the over-the-counter desk in charge of over-the-counter securities, in which he was dispensing literally millions of dollars in brokerage. This person would call up a broker-dealer, some of the biggest broker-dealers of the country, and ask that broker-dealer what his market was. The broker-dealer would give him the inside market, thinking he was talking to IDS. And this person would say, well, I'll take 100 shares. And they would give it to him. Later, I think we were able to prove that he was getting prices for his transaction which were lower than those prices if he were buying, and conversely higher prices if he were selling, than the previous sales before and the previous sales after his transaction was time-stamped, so that it was clear that in at least 12 or 13 brokerage houses were not only giving him the inside market, but were giving him something else. Now, my understanding is that an opinion by the administrative law judge has just come down on that case, and the administrative law judge found a 17E in a most peculiar circumstance. And let me explain it to you, which will emphasize what Mark says. In order to hide his transactions from IDS, his boss, he never dealt in shares of any securities in which the funds were dealing in. Instead of, he would instruct the brokers that he dealt with to confirm to an outfit in New York called Fishbein. Jaime Fishbein would then confirm to him. So the only brokers that appeared on his 204 forms, which he has to file as an associated person of an investment advisor, show two things: no securities held, bought or sold that the fund had bought or sold, and no broker that was used that the fund used. Now, as a matter of fact, as I understand the decision, the judge found that the cooperation of the brokers in obfuscating these transactions was a 17E. That was compensation, because he would have been caught, conceivably, had IDS seen the same brokers. And he also found, of course, that the broker's records were false and misleading because he was the customer and not Jaime Fishbein. The brokerage house of Jaime Fishbein was only put in there. But that's a very interesting thing, and Mark mentioned it, and I think this it emphasizes that transaction, that the compensation didn't have to be in money, although there was compensation in money, in the fact that they were facilitating the transactions for him. But the fact that they were violating the law for his benefit was also compensation.
If I could raise one other question, Mark. You've stressed that 17E1 should be looked at as a conflict of interest section, and Arthur has pointed out that the provisions of 17E apply even if the facts demonstrate that a particular transaction is beneficial to an investment company. Has the division or the commission set down any standards whereby we would give exemptive relief through the application process if an application was filed seeking relief from the provisions of 17E in order to allow an investment company to affect a particular transaction?
Yeah, I don't think there's any application that I can point to at the present time. But I would have no problem if somebody was going to go into an arrangement where he would seek compensation, and he could show that the benefit of the company, the benefit of the investment advisor, investment company was paramount. Let's go back to the equity research case. Let us assume there is an application on that right now.
That's the investors' research.
Investors' research,
yeah.
excuse me. Let's assume that person could show he had this little black box, which he claimed really gave the investment advisor, the broker-dealer, the opportunity to pick the shares, to give him research in a way that would inure to the benefit of the fund. And let us assume that this really had some value, and it was a real. It really was a facility for executing at the best possible price. And let's assume that the rental of that little black box was not out of line. And let us assume that other people wanted to rent it too. And incidentally, the broker that was going to use it and do the brokerage from rented it as a matter of trying to get something he couldn't get anyplace else. I think the division would look with some sympathy on a situation like that. But I put in a hell of a lot of conditions.
Yeah, let me emphasize one thing here, adding to Sidney's statement. There we have the money flow of a 17E transaction, but it's initiated by coincidental acts. You had good brokerage one way, you had a good product to sell the other way. It worked out. But where the compensation results from the person's dominance or influence over the investment company assets, then you're going to have a Moses v. Bergen type situation where there'll be a real question whether that compensation should be turned over to the fund. We
had another case where a investment advisor was putting out a book called a little pamphlet called Top of the Forum, in which he would collect data from many investment advisors and sell this data and give it to brokers for research and things of that sort. All of the participants that would participate in the compilation of this Top of the Forum publication got their books for nothing. Got complimentary books. One of them didn't. He paid $50,000 a year for it. Guess what? He was the principal broker for the fund. Coincidental? Hardly.
Okay, as we summarize Section 17A, this is a Caesar's wife's provision. Have to be above any question of doubt. They can't accept a case of eggnog at Christmas. They can't accept sponsorship into the Masons. Anything that would be a benefit to them from a person who's doing business or who intends to do business with the investment company. Now, Paragraph 2 of Section 17E discusses when a person acting as broker may receive compensation. The first paragraph of that says that they may receive compensation, usual and customary broker's commission in effecting transactions on a securities exchange. Now, the problem with that is that it appears in an era of fluctuating and negotiating commission rates that there is no such thing as usual and customary brokerage commissions anymore. Therefore, we have promulgated a safe harbor rule. But let me emphasize this. If you find someone in an inspection not relying on the safe harbor rule, ask them to document the fact that they are only charging the usual and customary broker's commission. The commission in the release proposing the safe harbor rule basically said they were extremely skeptical that anybody can do that. If you find that, be equally skeptical. The safe harbor rule is indicative of the type of rules that the commission has begun to adopt starting in January of 1979. It has three provisions, and let me go over these somewhat in detail, not necessarily because of the importance of this rule, which it is an important rule, but because it'll give you some idea of how to deal with this new type of rule in which the commission places extreme emphasis on the competency of our people out in the field, the examiners. First, what the first paragraph of the rules basically says is that the affiliated broker cannot receive more than what is the going rate. That is what other people would receive, other brokers would receive for effecting a similar transaction in similar securities. That is the standard of fairness, and it would be the same standard of fairness that the Commission would recommend, that the division would recommend a Commission would apply if we got an application here on, for such purposes. The second paragraph requires the Board of Directors, including a majority of directors who are not interested persons of the investment company. And this brings us back to Arthur's discussion about 3 hours ago on interested persons. That those persons must establish procedures under the rule, if they intend to rely on the rule, that are reasonably designed to affect the standards of fairness in paragraph 1 of the rule. Now, these procedures must be reasonably designed. Now, we've allowed them a lot of leeway, and the reason we've done that is because of our faith in our ability to rely on the examination program. You have to look at these procedures. If the procedures are calling up the guy's brother-in-law, that's not good enough. If it's just reading an article in the Wall Street Journal, that's not good enough. If what they're doing is on a daily basis calling up 3 unaffiliated brokers and asking them what they charge for particular classes of transactions, that may be much better. Heavy dependence by us on your knowledge of the securities industry.
I would think this also, it would one of the evidentiary factors to give great emphasis to is what they're charging unaffiliated clients for the same type of transaction.
That's right. Again, the Commission has not required them to give the person the best price that he's giving anyone. In other words, he may, in establishing a new account, have a loss leader for a while. But where you do see that, be suspicious, inquire and ask questions. And indeed, that may raise questions under Section 36 also, if in effect the brokerage from the fund is being used to support somebody's business with someone else. In other words, to offset those costs. Finally, there's a record-keeping requirement. They have to have certain particular information and any other information that I'm sorry, I skipped a paragraph. Or a subparagraph. One, they have to, on a quarterly basis, determine that transactions that have been affected during that quarter are in compliance with the procedures they have established. And lastly, they need record keeping, and the record keeping requirements require certain per se information, like the terms of the transaction. But in addition to that, any information that the directors used to determine compliance with their procedures for each transaction. If you are unable to reconstruct the transaction to your satisfaction, then in all likelihood there is a bookkeeping violation present.
I'm sorry. Mark, you identified this as the safe harbor rule. This is new Rule 17E1, is it not? It is Rule
17E1, yeah. Again, let me just mention one thing which is really parenthetical. We're putting out a fair number of rules right now. Please just don't rely on CFR. Check to make sure particular regulations have not been updated. For example, right now CFR has a Rule 17E1 in it regarding over-the-counter transactions, which the Commission has rescinded as obsolete. Check either with the flyers that I think are put out by the Commission, or in effect shepherdize our releases, or CCH, Federal Securities, or something to make sure what the updated rules of the moment are. There's two other parts of 17E2. The second one allows a maximum 2% commission in a secondary distribution. You'll rarely come across that. And the third is basically the catch-all. In any other transaction, they can get a 1% commission, and that would include over-the-counter transactions. Now, what do you really have to look for in doing these in judging these transactions? The most important thing you have to look for is to make sure that a broker is actually needed in this transaction, that there is not interpositioning. Remember, in almost all instances, an institution can go to the market maker, doesn't have to go through a broker, let alone an affiliated broker. If you find that, read the Delaware management case. It's an SEC administrative opinion. Real serious questions are raised. Secondly, when referred to the Stedman Securities Corporation decision, the commission talks in very abstruse terms that where no broker is needed, you can't pay one. And they also say that a person can't wear two hats and get paid for wearing both hats. What the commission is saying there is that if somebody would be acting in a management capacity, they can't also be paid for acting in a brokerage capacity. The factual situation there was that Stedman tried to take a soliciting broker's fee when, in effect, Stedman would only be soliciting himself because he was also the management company. The determination of when to solicit is done by the management company, and anything else he was doing was not in effect a true service. He was filling out some paperwork at best. He could have been doing that, and he should have been doing that in his management capacity. Now, what the commission said there is not that there should have been no tender solicitation fee, but what they said, in effect, is he couldn't retain it. What he should have done, and for this we would look to authority of Moses v. Bergen and all the other recapture cases, is he should have taken that fee, which he claimed he got, but in effect he got it for his influence over the investment company assets, should have taken that fee and returned it to the investment company. Now I'm going to discuss a historical footnote that I've had no actual experience with, and no one else on the panel here has except Sidney, so we're heavily in reliance on him. But it's the question of customer-directed give-ups. The reason it has such a clumsy name is there are what's in the brokerage industry what's called directed give-ups, but that's when one broker directs the give-up to another broker who provides certain services to the first broker. It's payment for real services. Here, what we're dealing with is something that existed in the era of non-negotiated fixed brokerage commission rates. Now, as we had talked about actually in lunch yesterday, which was not taped, thank God, wherever you have business and you have two people fighting for the business, you're going to have negotiation, whether it's recognized or not. Now here, the fighting, the competitive negotiation could not be price negotiation. They could not, for example, charge an investment company less because it was an institution providing great business. And they could not, because of stock exchange regulations, charge them the same amount but pay part of it back, rescind part of the cost. So the way that they negotiated commission rates was to allow the investment company to direct to another broker part of the transactional brokerage cost. Now, the broker that he would direct it to is one who was selling investment company shares. generally in proportion to the amount of shares he sells. Now, what happened is that some shareholders sued, claiming that what we had here was the use of a real asset, that is the brokerage, of an investment company. In other words, it's not an asset in accounting sense, but where it's generating so much brokerage business, there was a certain value to it, even if it's not an accounting value. Now that asset, that value, was being used not to benefit the investment company, but to benefit the investment advisor, because the more sales there were, and this encouraged sales, the bigger the asset base would be, and the bigger his management fee would be. And there was no articulable proof that that would benefit the investment company. The commission, at least the division, has generally held that size per se is not an advantage to investment company shareholders. Now, what these people said is that the investment company and the investment advisor should have considered whether to create a broker-dealer affiliate to get these directed give-ups and to pass them on to the investment company in the manner we discussed in the Stedman decision.
Let me give you an example in this one thing, how it worked. The funds were competing for sales, were competing for broker-dealers. They would go to a New York member, and they would make an arrangement with the New York member that he would give back as much as 60% of the commissions that he made. There was so much, remember this, in order for him to give up 60%, he wasn't losing money. This is not an eleemosynary institution we're talking about. So he gave up 60%, up to 60%. 50%, 40% was also common. Now, every month, the broker-dealer, the investment advisor to the broker-dealer, would give that executing broker a list of how much money he should send to other member firms that he designated. This was for sales, and and in many cases it averaged as much as 2% of the sales. In other words, if a person sold $100,000, he would get his regular compensation, and then he could expect to get a check from the executing broker, courtesy of the fund, for an additional 2%. Now, I don't have to tell you that this has the seeds of corruption. Because what happens? The investment advisor has to create brokerage to service this type of a situation. It feeds on itself. Pretty soon we found that brokers, big selling brokers, were demanding more than 2%. Were demanding more of the brokerage, and to give him the existing brokerage would deny somebody else the additional compensation, would deny somebody else compensation, because obviously, legitimately, the fund could only do so much brokerage. So you always had the possibility of churning in order to service this give-up business. Now, go ahead, and I'll interject some more stories in a minute.
Again, it's good Sydney's here, because basically we're the generation that came with Mayday and haven't seen this. Hopefully it is dead, but we can't preclude the fact that something similar is going to develop someday, that the ingenuity of people may create something new in a different circumstance. But anyway, there's a series of cases that were directed to this, whether advisors and investment company directors should have considered establishing affiliate broker-dealers to either execute the transactions themselves or to receive the give-ups and pass them on. These will be discussed, I'm sure, in the context of Section 36. Now, I'd like to say a few words about Section 10F, which is the relationship of the investment company to certain underwriting syndicates. Basically, Section 10F says in general terms that the investment company can't buy securities from an underwriting syndicate of which enumerated persons, mainly affiliated persons, are members. The purpose is obviously anti-dumping. There was a great problem before the 1940 Act where investment advisors were dumping securities that they couldn't sell in underwriting syndicates into the fund, or they were using it to park so that they wouldn't have to carry these securities financially until they could sell it. There's two minor rules under there. Section 10, Rule 10F1, which deals with when a fund may buy while acting as an underwriter from an affiliated underwriting syndicate, and not as a principal underwriter, which is already covered by the section itself. It has a parallel provision in Rule 17A1. Rule 10F2 says when they can buy warrants from affiliated underwriting syndicates. The main rule by far is Rule 10F3, which is when they could buy securities generally. Here we require them to be, at this time, registered securities or municipal securities. I would not be surprised if sometime in the future we would allow certain governments, but at this time the Commission just has not had the experience with it through its application process. I just want to mention a few of the highlights of the rule. I think it has provisions down to paragraph I, so that's 8. I'll just mention a few of the highlights. One, we require speed. We require it to be by the end of the first full business day. We don't want the underwriters sitting around testing the waters, finding out that it can't sell, and then dumping it. 2, we have certain quality requirements. The first is that for registered securities, the issuers must have been in continuous operation for 3 years. For municipal securities, if they're operating for 3 continuous years, we require them to have to be of investment grade, which does mean the top 4 levels of nationally recognized rating services, such as Dun & Bradstreet, Standard & Poor's. If they've been operating less than that, they have to be of the top 3 gradings. The spread, we have another one of these comparability standards, going rate standards. It can't be more than other underwriters get in similar underwritings in a comparable period of time. It allows the directors this standard, let me say, allows in determining comparable securities, you would have such things considered as yield, rating, degree of subordination, and even market acceptability. Where they're dealing with stuff that they may get stuck with, you would expect there would be a premium. The Commission recognizes that. Again, we have directorial review, same general concept. They must establish procedures reasonably designed to provide compliance with the rule's fairness standard. There has to be an annual review, which I don't think I mentioned under Rule 17E1, but an annual review to determine that the procedures are still appropriate in a changing securities market, and quarterly determination that compliance exists. And finally, records, all the material so that you can recreate the transaction. If the examiner cannot recreate the transaction, if nothing else, we may have a records violation. And with the records violation, then in fact, you would conflict with the entire rule.
Mark, aren't there also certain volume limitations on the
There
purchases
are, right.
of
I
securities?
just discussed the highlights. There's limitations on the amount of assets
Right.
by the investment company that may be committed, and there's limitations on on the amount of the offering that they can take down. But that's fairly simple. Anybody that can be read in the rules.
That's right.
I think, like Rule 17E1, here the ingenuity of the inspector in the inspection process and the competence of the inspector is put to the test. It would seem to me that if an investment company which is being inspected is buying original issues, then I think the inspector has to determine who the members of the syndicate are, to see whether any affiliated person is involved. If there is an affiliated person involved, he then must go to the records of the investment company to determine whether they're relying on the new rule 10F3. And he must look to determine whether the board has come up with a set of standards, whether the board is reviewing those standards, and whether generally the purchase was made in compliance with new Rule 10F3.
Let me emphasize one thing, which is the importance of Section 10F. 10F is unlike anything in Section 10. We're not dealing with the composition of board of directors. Think of it as a Section 17 transaction. It's the affiliated persons getting rid of property that they ordinarily would be stuck with by selling it to the investment company. It philosophically belongs in Section 17, and we treat it just as seriously.
Yes, this section is known as the anti-dumping section, but it seems to me, looking at the language, that the affiliated person could not only acquire securities during the existence of the underwriting syndicate from the underwriting syndicate itself, but in addition to that, it couldn't go into the open market and purchase those same securities that had already been registered and sold in the secondary market to support or to otherwise help the underwriting effort.
Howie doesn't mean affiliated, but he means the statute here, the section here, is directed against the investment company, and the affiliated person who might be in the syndicate is really prevented from causing the investment company to go in to support the syndicate. It's a peculiarity here that the violation of the law in the first instance is with the investment company, which is different from 17F, where the violations must be committed by the affiliated persons. But an investment company, like any other corporation, doesn't act by itself. It must act through its affiliated persons.
Okay, thank you. This, if there's no questions, this completes the discussion of Section 17, and our next tape will begin our discussion of capital structure of investment companies.